This is the 13th question of Mr. Ask Me Anything. The question is from Section 3 of Indian Evidence Act 1872, and the question is, what is the difference between fact in issue and relevant fact? If you want to watch the 13th question of the channel, please click the I button or go to the link given in description below. Before getting to the answer, let us try to understand the importance of evidence. It is mentioned that the most important rule of evidence is that when parties are called to give evidence, only the relevant facts are to be admitted in evidence. Here, Section 5 of Evidence Act provides that evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of other fact as are hereinafter declared to be relevant and of no others, which means that the existence or non-existence of every fact in issue and the other fact which is declared relevant can be given in any legal proceeding. Let us see what is given in a Section 3 of Indian Evidence Act 1872. Facts in issue. The expression facts in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceedings necessarily follows. Okay, let us come to the explanation. Whenever under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to show issue is a fact in issue. To have more clarification, let us come to illustration. A is accused of the murder of B. At his trial, that means in the case, the following facts may be in issue. Several facts like that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that A at the time of doing the act which caused B's death was by reason of unsoundness of mind incapable of knowing its natures. These several facts are facts in issue. So, fact in issue in the plain sense means facts which are in issue and form the subject matter of the court's decision. The questions relating to a fact enabling the court to give decisions are fact in issue. So, facts in issue are those facts which are alleged by one party and denied by the other in the pleading in a civil case, or alleged by the prosecution and denied by the accused in a criminal case. Let us take an example. A is accused of murdering B. At trial, the following fact may be in issue: that A caused B's death. It refers to the questions whether A has caused the death of B. If the answer is no, A is discharged or acquitted. If the answer is yes, the following questions will arise. That A intended to cause B's death. If A caused B's death, the next question arises is whether A had an intention to cause B's death or not. If the intention, like mens rea or mental illness, is present, it is murder or culpable homicide, and A is awarded serious punishment, that is death or life imprisonment. Otherwise, if intention or mens rea is absent, it amounts to accident, which is a defense under Section 80 of Indian Penal Code. If the accident is by negligence, the punishment is up to 2 years imprisonment or fine or both. From the above illustration, the questions like causing death of B by A with intention or by accident or by negligence or in act of defending the grave and sudden provocations given by B and so on are all facts of issues, as these are questions arise in court to decide whether the facts are true or false. Under same section, that is Section 3 of Evidence Act, let us try to know what is relevant fact. One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of facts. Section 3 further provides that the fact connected with other fact in any of ways referred to in Section 5 to 55 is said to be relevant fact. The word relevant has two meanings. In one sense, it means connected. In another sense, it means admissible. In simple words, a fact is said to be relevant to another if it is connected with other under the provisions of Evidence Act. Here, the expressions relevancy means connection between one fact and another. Relevant fact is a fact that has certain degree of probative force. Relevancy can be of logical relevancy and legal relevancy. Let us try to understand what is logical relevancy. A fact is said to be logically relevant to another when, by using our logic, it appears to us that one fact has a connection on another fact. Facts which are logically relevant are not provable. Legal relevancy. A fact is said to be legally relevant when it is expressed as relevant under Section 5 to 55 of Indian Evidence Act. Here, in case of logically relevant and legally relevant, the main problem in this regard is deciding which fact is legally relevant as well as logical in nature. A fact may be logically relevant to a particular case, but there is no guarantee that it will be legally admissible in the courts. So all the evidences that are to be produced in the courts have to pass two obstacles. It has to be both logically relevant and legally admissible at the same time. When a fact is connected with another fact, it is logically relevant, but it is relevant if the law declares it to be relevant. If it is not declared by the law to be relevant, it is not admissible in evidence. Every fact that is legally relevant is also logically relevant, but every logically relevant fact may not be necessarily legally relevant. Under the Evidence Act, a fact is said to be relevant to another when it is relevant under the provisions of Indian Evidence Act from Section 6 to Section 55. For example, in confessional statement made to wife by her husband, husband said to his wife that he had committed a crime, that is murder or rape or theft. If the wife gives evidence as to the commission of a crime by her husband, it is not admitted in evidence under Section 122 of the Indian Evidence Act. The Act doesn't deal with logical relevancy, therefore it is said that all facts logically relevant are not provable. However, legally relevant facts are provable. Okay, finally, let me summarize the difference of facts in issue and relevant facts to make the answer more clear. In a tabulation form, in a number 1 point, a fact in issue is a necessary ingredient of a right or liability because from such fact, either by itself or in connections with other facts, existence or non-existence of a right or liability necessarily follows. While relevant fact is not a necessary ingredient of a right or liability, but is one that merely provides probability of the existence or non-existence of any ingredients fact of a right or liability. In a second point, a fact in issue is called the principal fact or factum provendium. A relevant fact is called the evidentiary fact or factum provendi. Here, factum provendium is also known as facta provandum, and factum provendi is also known to be as a facta proventia. In a third point, facts in issue are the matters which are in dispute. They are the facts out of which some legal right or liability necessarily arises and upon which a decision must be arrived at. They are matters which are affirmed by one party and denied by the other. While the relevant facts are not themselves in issue, but they are the foundation of inference regarding them. Here, inference means a conclusion that we draw about something by using information that we already have about it. Thank you for watching Ask Me Anything. Please do like, share and subscribe to support my channel Ask Me Anything. Your one subscribe will give me a new platform of teaching. If already subscribed, then thanks for your subscription. And press the bell icon to get interesting questions and latest updates.